My name is Adam Stone. As you can tell, I am not Shannon Welsh Levin. As you know, she is the owner of SoCal Realty Law. I am a transactional attorney. I've been working with the firm a little bit under a year, and I'm happy to be a part of the firm. In addition to transactions, I have experience working in real estate litigation, unlawful detainer, other areas within real estate and business law. So I'm really excited to be a part of the team. And what we're talking about today really aligns with things that we're working on currently, a lot of things that come into fruition with 2025. And then unfortunately with the wildfires that we've seen over the last few weeks, the price gouging and other statutes have come in to talk about those. Before we get started, I would like to make sure that I properly introduce this webinar. This is the first webinar of 2025. Shanna, unfortunately, could not make it today. She had another arrangement for a case that she's working on, but she sends her regards and love to the rest of everybody. In terms of our realty law, I want to make sure everybody knows exactly what our mission is. We help property owners protect their investments, maximize value, avoid liability. We do that through having strong contracts, helping clients deal with tenant matters, and helping in litigation disputes as we can. So, with that being said, our team, like I mentioned, has continued to grow. In addition to myself, we added two other attorneys to the firm staff in the last year, or up to four now this past month. Diana and Sally has joined the team. She is a litigator that some might be familiar with. She has a history with SoCal Realty Law already, and she joins the team along with myself and Jim Delaney, litigators and transactional attorneys with the team. Before I get started, I do want to emphasize and reiterate that this is not legal advice. While we do want to provide some education, some information on topics that we discussed today, if you do have a legal question or want to set up some time to talk directly about a legal matter, please reach out to us. We can talk about that offline and make sure that we address your questions specifically to your contacts or to your circumstances and to your context. So if you have any other questions about that, feel free to send something in the chat. We'll make sure to follow up. Okay. So since April 2020, our firm, Chana, mainly has been leading the way in terms of providing these webinars. We're excited and honored to bring these webinars to our client base and the rest of the community because we know that this information is vital as you go throughout your lives and handle your own real estate matters and whatnot. So with that being said, we are getting into the next year. Happy New Year to those that I have not talked to yet this year. We're just at the very finish of being able to say that with January almost coming to an end. But we're excited to have this topic for you. Now, unfortunately, it is on a sad note, obviously. As a firm, our thoughts and condolences go out to those who have been impacted by the Los Angeles County wildfires. I know people personally who have been devastated by this event, so we obviously don't want to take it lightly. But what we're talking about today as it relates to price gouging is something that while it's topical right now for the LA wildfires, is something that applies throughout the state on a regular basis. So we want to talk about Penal Code 396 and the price gouging during states of emergency. Now, during a state of emergency or a local emergency, which we'll discuss and define later, there are tenants, consumers who are at higher risk of being victims of predatory practices from merchants and landlords who are looking to take advantage of the situation. Now, Penal Code 396 is set up and really has to be looked at for consumers and tenants. So the way it's designed is as a level of protection where it is broken up by industry and provides protections from the initial 30 or 180-day periods with the ability for extensions and the ability for the government or whatever the government agency is that has declared the emergency to extend it as necessary. Now, Penal Code 396, as it indicates, is a criminal statute, and as a criminal statute, it carries misdemeanor liability, which can be punishable up to 1 year in jail and or a fine up to $10,000. Now, Penal Code 396 does tie in civil liability, which we will discuss in a little bit as well, through Business and Professions Code Section 17200. So we'll talk about how that attaches and what that means for people using that law to protect themselves and go after those types of predatory practices. But there is a civil aspect to it to go after damages and collect damages for being a victim to this. And while we're talking about new laws for 2025, this is a relatively new law as well, became effective at the beginning of 2021. Now, by industry, Penal Code 396 does break things up. Now, in regards to housing and other goods, generally speaking, there's a 30-day restriction from charging 10% over the pre-emergency price for rental housing, goods, services as listed here, and other things that could be seen as emergency supplies and items during that event. Now, the 10% cap may go beyond that as needed to cover price increases when it comes to increases in stoppages, logistical issues, things like that, which can cause. But in regards to how it's impacted through stores, through merchants, and through landlords, it is something that they keep a close eye on that 10%. For a landowner who is renting out a property, that 30-day restriction does create that 10%. Now, what's important is to note that this 10% cap doesn't exceed local rent control ordinances that are already in place. As many of you know, San Diego County has a 8.6% rent cap at this point. So this 10% wouldn't be able to exceed that. And the eviction rules still apply. So if somebody violated the lease under, failure to pay, nuisance, other damages not related to the state of emergency, obviously, that can allow for without violating this law. This with the housing and the rental. Now, moving on to contractors, this is a specific point of emphasis for this penal code because we are talking about states of emergency, things that call for emergency repairs, reconstruction, redevelopment, things like that. So using the 180-day timeline, this puts a restriction on, again, 10% over the normal pre-emergency rates for these services and items. Now, again, there can be an ability to exceed that 10%, but that all comes down to whether or not that can be proven as a need to cover those additional costs for labor or goods or things like that, which again could be affected by the state of emergency. Now, from a plaintiff's perspective, we represent a lot of plaintiffs at this firm. We look for ways to prove our case. So we're looking for evidence, things that can help go toward whether or not a contractor is price gouging in violation of Penal Code 396. What that can mean is having previous bids, previous estimates before the emergency to then compare to what is provided after the emergency. So you can document and compare the difference between the pre-emergency rates and the post-emergency rates after Penal Code 396 is triggered. Now, if you don't have that track record to prove that, you might be able to show it other ways by looking for advertisements or things that are, again, establishing the pre-emergency rates, or you can use what's established as the fair market value, but that would be a little bit more subjective. That would take a little bit more work to find multiple estimates in a certain range that can then show the contractor that might be in violation of the price gouging is exceeding that range and going beyond that. So that is an important thing to keep in mind for those contractors that are handling these types of emergency rates and repairs. We don't want to discourage that. Obviously, it's a great service and need during these times. We just want to make sure that if you are handling these things, you are documenting your rates, your reasons for price hikes, and making sure you can show that these additional rate increases are tied to additional costs on your end, so there might not be a violation, 396 inadvertently. Now, when we're talking about housing rentals, this doesn't always mean including hotels and short-term rentals, but Penal Code 396 does tie that in. Again, the 10% cap, which would prevent people from charging excessive rates, but owners may show that they have seasonal adjustment rates and additional costs to provide the rooming and the housing and the rentals that can allow for an increase beyond the 10%. So with that, you're looking at really having the ability to tie in the need for addressing situations, but at the same time allow for some flexibility when those are considerations, when there are things that cause natural, like we were talking about before. I do have a question from the audience. Did the governor declare a state of emergency for the entire state or just the counties impacted by the wildfires? That's a great question. That gets us to our next slide. Our next slide talking about the definition of state of emergency or local emergency. Now, typically speaking, states of emergency are declared on a county by county basis. So with that, you have situations where there might be emergencies that extend beyond counties, but for the most part, things are isolated to being applicable just to that county, whether or not the declaration comes from the governor, the mayor, local municipality, board of supervisors in the county, things like that. So what that means is you can look and track any type of price gouging protections that might apply to your county by going to the Office of Emergency Services down at the bottom. There they track all the state of emergencies, the local emergencies that have been declared, and what applicable protections are in place. Sometimes they have protections that cover just the contractors. Sometimes they have protections that cover and apply to the goods and services being overcharged by 10%. And sometimes they have multiple declarations that cover those different items. So here, what we're talking about is the state of emergency applying to the county of Los Angeles only. So the price gouging rules, that sort of Penal Code 396 application wouldn't apply to San Diego County, for example, right now, because there isn't a state of emergency. Now, I included in this slide a photo from last year when we had flooding throughout the city of San Diego specifically, but other parts of the county. There was a state of emergency declared for San Diego County, and the price gouging laws did apply. So that was last year, even the year before that as well, there were state of emergencies declared based on the flooding. So these price gouging laws, while pertinent to what's going on with the Los Angeles wildfires, they are things that come up regularly throughout the state at different areas as emergencies come up, unfortunately. So these price gouging laws, they are something you can track. We would advise that if you think that there might be a state of emergency or something affecting your area, that you take a look and see if there might be some applicability for your situation. And if you have any questions, again, please reach out. Now, when we're talking about the liability, everything really is focused on the penal code, the criminal side, the punishment of fines, penalties, some jail time potentially, which is rare in situations. But again, Penal Code 396 does include specific ties to Business and Professions Code, Section 17200. Now, what that means is each violation of Penal Code 396 constitutes unfair competition and an unfair business practice, which is a violation of the Business and Professions Code 17200. Now, what that does allow for is civil liability. That civil liability can mean damages, restitution for money spent on those prices, those excessive prices. They have specific penalties for targeting disabled persons or senior citizens. They have other penalties for disobeying and going beyond injunctive orders, court orders that state that the person has to stop the violating conduct. And then, there are return fee provisions, court cost provisions, other things that can attach to make it a very aggressive statute for someone to use if they're the victim of Penal Code 396. If you think that there might be price gouging affecting you, then there definitely is the ability to use this section in particular to your advantage to address your rights, defend your rights, and try to obtain damages. Now, the statute of limitations is 4 years from the date of violation. So that means there is time after the state of emergency to gain evidence, gather evidence, and hopefully get at a better state to then go after any violations. And along with individuals being able to bring civil actions, this gives the cities and other municipalities during that state of emergency the ability to go after civil actions as well. So it's not just a criminal statute. There is the ability to go after bad actors financially and go after companies, construction companies, whoever it may be in that space that could be violating the rules. A Business and Professions Code that was codified in 2000, but again, it attaches with Penal Code 396, which came into play in 2021. So moving on, we're getting back into the new law discussion for 2025. We had some things on the ballot during the 2024 election. Just to summarize those, Proposition 33 did not pass. That would have repealed the Costa-Hawkins Act and allow local governments to impose rent control laws on vacancies in new construction. So with that not passing, cities are still allowed to provide rent control ordinances as it relates to existing tenancies, as we see in the city of San Diego and other municipalities. But once that vacancy comes into play, it doesn't put a cap on being able to adjust the rents at that point. So that was a big win for landlords, property owners, and that was a big point that we were advocating for as a representative of landlords. We wanted to make sure that you have the flexibility to make sure your rents stay current and able to cover the costs that you need and still build wealth. Proposition 5 did not pass. This was a local measure for including bonds to have a lower threshold for voting. That would have potentially made projects a little bit easier to get funding, but that was voted down. Also, Proposition 32 did not pass, which was addressing minimum wage for workers across the board. Now, new law that has taken effect just about 3 weeks ago. This is Civil Code Section 1941.6 and 1946.9. This changes the law to clarify the duty of a landlord in reaction to requests to change locks, especially when it comes to the allegations or the potential or showing of domestic violence. So as you see here under prior law, there were more standards that the tenant had to establish to show that the need for changing the locks were there. So now the need to change the locks becomes a little bit easier of a threshold, and it protects the tenant from any retaliatory action by the landlord for having to change the lock. So more tenant protection there, but it's directed towards reducing and protecting against domestic violence. Another new law section, Civil Code Section 1950.5, addresses security deposits. Now security deposits have to be better documented by landlords in terms of having photos and other documentation to show exactly how deductions are calculated for security deposits. We as a firm, we try to encourage our property owners to document the condition of the property going into the lease and after, for their own protection and for the ability to assess and collect damages if there is, property damage left by the tenant. So this follows along that line to better document and protect yourself. It does help both sides here if the landlord is doing what they're supposed to be doing in terms of making sure that the property is ready to go, moving ready for the tenant. Then this helps to document the condition that the tenant leaves it in for then the landlord to go after that security deposit if there's excessive damage there. So tenants now can require that, but again, for landlord protection is something that we would advise as well. No. Previously, there were charges possible for having to provide notices, having to even go and accept checks for the rent payments. Now that's no longer allowed. So if a landlord does charge a higher rent or charge a fee on top of accepting rent for taking check, or if they charge for providing a notice, that is a violation. So that's something that landlords should be careful of, just in case that's a practice or has been a practice that can no longer be the case as of the beginning of this year. Now, as it comes to higher security deposit for service members, there is now a written statement that must be provided that documents and explains the reasoning behind the higher security deposit. As it turns to the eviction cases, the lawsuits, the extension timelines to respond, this is a big change that has taken effect as of this year. Our office has been navigating some of those changes, especially around the new year. And what we're seeing now is everything taking hold. So previously there was a 5 business day response timeline for tenants who were served eviction paperwork. That has been doubled to a 10 business day timeline. And as a note, this does not include Saturdays, Sundays, or judicial holidays like Martin Luther King Day this past week, Martin Luther King Jr. Day this past week. Also timeline shortening for demur motions. So this works a little bit in the landlord's favor to move cases along, but the response deadline going from 5 to 10 business days does prolong the timeline potentially. So that makes it even more important to make sure your notices are accurate, because when you have these extra deadlines put into play, that timeline can get a lot longer if things aren't correct and have to be refiled. Now, for a long time, we've seen residential leases have a very different treatment than commercial leases. That is starting to change. This law that has taken effect earlier this month is regarding qualified commercial tenants. Now, qualified commercial tenants are basically small businesses, those that are less than 5 employees, restaurants for fewer than 10 employees, nonprofits for fewer than 20 employees. What it allows is for these businesses as qualified commercial tenants to receive notices, 30 and 90-day notices for rent increases, longer notices for getting their lease terminated, when previously that could be an automatic or an immediate termination, and then other requirements that previously were not established for commercial landlords on commercial tenants. Now, in terms of being able to establish yourself as a qualified commercial tenant, there is a duty to provide a written statement that basically acknowledges the size of the business and also the tenancy and the period of how long the lease actually is in place. So there is a duty on the tenant, if they want to take advantage of these laws, to provide that documentation. But once it's done, then the laws, the bullet points up top would apply in terms of the new timelines for notices. So those who are commercial landlords or commercial tenants, you may start to see that more in this space. If you have any questions about that, please reach out. We can help you review those notices or prepare those as needed. Regarding restrictions on applicant screening fees, previously there were no there were less obstacles, to put it that way, in terms of having landlords being able to charge a fee for applications. And it could be charged without a lot of likelihood for the tenant to even have the ability to rent the space. Now, as you see here, the new law prohibits that. There will be a lot more ability for a tenant to receive a refund for their fee if they're not able to secure the tenancy. And then from the landlord's perspective, it does add in, again, more paperwork, documentation, evidence gathering to make sure there's a defense there if the application fee is not refunded, what the circumstances for taking the application fee were in the first place, and the ability to have the application fee kept, provided that that went through the application process, they did the background check, things like that to warrant keeping the fee. Now, this is a new law that applies only to larger commercial properties. This is more than 15 residential units. Now, it allows for tenants to have the right to receive positive credit reporting for making rent payments. And that is a requirement the landlord has to offer at least one national reporting agency if the tenant desires. So that's, again, for units more than 15, but that is a new benefit for tenants who are looking to build their credit through showing the positive rent payment history. Now, we've seen additions and some changes, updates to the discrimination law, to the discrimination laws. Now, previously, there were things that were not taken into consideration, such as hair texture, hairstyles, braids, locks, whatnot. But now that is brought in, it also does allow for what's called intersectionality. Now, that allows for the court and for the law to be more receptive to the idea of how these different considerations, these different characteristics can be protected and can come into play as opposed to just one single individual characteristic. So this allows for more applicability of the law. That's what the intent and the focus and the goal is. So again, from a landlord's perspective, again, with the screening of applicants, there are some great best practices that we can share with you. If you want to reach out, we can put those together for how to screen applicants in a way that might be less likely to run into these challenges in terms of improper screening, racial bias, things like that, discrimination. Now, AB 2579, balcony inspections. That is a law that was supposed to take place and come into effect earlier this month, yes, but is now extended out to the 2026. So with that being said, the beginning of 2026 means that property owners now have a longer time to go through the inspections. The related law also adds in a additional professional that can complete the inspections. Previously, it was only contractors, architects, added in civil engineers to allow for the inspections. And as you see here, there's a building requirement of 3 or more units that has wood decking, wood patios, wood stairs. As you see here in this photo, this is an example of a property that would be subject to these laws because there are wood or wood-based products that are part of this stairway balcony deck setup. So here with the extension, initial inspection must be completed by the beginning of next year. But after that, there is a 6-year timeline to complete follow-up inspections. Condominiums are on a similar, the stair to the door included. Yeah, so it would be any structures exterior beyond the exterior wall. So if there is an exterior door, for example, on a staircase that came off of that exterior wall to get up to the upper level door, then yes, that would be something that is subject to AB 2579. So with the elevated elements, that can include these items, and for condominiums that have a similar law that is on a different timeline that has gone through its own analysis in a way that they are also getting inspections required, but their timeline has already started for some, and then it's also being updated to have a every 7-year clock for condominiums. Now, this is another large unit situation because this will be exempt for properties 15 units or smaller, AB 2216. This is a mandatory pet acceptance rule that would be basically allowing tenants to have pets without needing to go through an emotional support animal process or something along those lines. Now, for that, there would be a fee that can be charged. But it would aim to restrict pet deposits and fees as we saw, but there would be something that still would be there. But this is going back and forth through the legislative branch. This has not received approval yet. There were some red lines as of the last legislative session. So we'll see this year in terms of how much progress is made or whether this ultimately comes into law or if this does not make it as written currently. Now, two big items and components that have one has been introduced into law but has been put on hold. The other is, again, not yet passed, the Corporate Transparency Act. We've talked about the Corporate Transparency Act in the past. This is something where it is looking to get more information about entity ownership. Now, our firm, we're big advocates for protecting your assets, getting assets out of your personal name, putting them into entities like LLCs and corporations, trusts, whatever you and your tax professional find is best for your structure. But at the same time, this law would look to mandate reporting on the ownership for those entities. Now, in states like California, the reporting requirements, which are being suggested to be ramped up by SB 1201, they're not as confidential as other states like Nevada, Wyoming, Delaware. Those states are very restrictive in terms of the information that is given out about entities. So this law, Corporate Transparency Act, looks to get around that by requiring the registration of entities on the FinCEN website. Now, for California, there are a lot of names, contacts, other pieces of information that are already required. So, having to provide more information for ownership may not be as impactful as other states. Now, with SB 1201, what they're looking to focus on are beneficial owners, those with 25% ownership or more in an entity having to be registered. But again, that has not yet passed law. Now, in regards to the Corporate Transparency Act, that was enacted, that was put into law, but just before the deadline to become effective and to be registered, January 1st of this year, there were court orders to put a hold on that process and that enforcement. Now, it was slated, there was some back and forth with the courts. It was slated to get enforced on January 13th. In late December, but a couple of days later, there was another court action, another court order, which halted that enforcement. So now it's still back on hold with no clear timeline on when enforcement will go back into effect. Now, the enforcement process, the penalties can be relatively harsh for not being registered. Penalties include daily fines of up to $500 a day, which is one of the reasons why the law was challenged in the first place. So we'll see what happens when the law is actually brought into effect. But again, with the ability for the property owner to have asset liability protection and things like that, we find that is much more beneficial to have to worry about these types of laws, the Corporate Transparency Act, as opposed to avoiding those laws by staying in individual personal liability ownership. Now, we'll have future webinars talking about the LLC formation and how that ties in to real estate ownership and development. But, for now, what we're talking about here is really focused on how to stay compliant when the rules come back into enforcement in a way that doesn't require excessive registration or anything beyond what's already required through FinCEN. So our firm has already been helping clients with this process before the January 1st deadline came into play. It was brought into law last year in 2024, last January. So we've been working through this throughout the year with the idea that either companies that were formed after 2024 had a 90-day, originally, as stated or as written, had a 90-day deadline to comply. But now with that being on hold, that's no longer the case. So we'll see what that comes back with. But most entities that we see outside of financial institutions, nonprofit entities, those that already have compliance and registration guidelines, typically, a lot of entities are not exempt from the enforcement. So when it does come back into play, most of the entity owners out there will have to register with FinCEN for the Corporate Transparency Act. So we're looking out to see when that is going to happen, because once it does, we'll be here to help clients get through that phase, because it will be something that is impactful for making sure to avoid those penalties and fines. Mm. I'm going to take a moment to see if there's any questions from the group. No, in terms of the declaration for the state of emergency, just to reiterate, that state of emergency was not declared for the entire state. It was declared only for Los Angeles County. If you scroll back up, if you check the Office of Emergency Services website link that I provided down below, yes, we will make the slides available. If you check this link, every aspect of the law being applicable to every situation, and there is some specificity there. Now, with 2025, while we have some time, there are some other laws that have come into play. One that was brought up in the chat deals with the buyer broker representation. For those that aren't aware, there is a new requirement now that buyers are supposed to have a buyer representation agreement signed with their agent, with their broker, prior to entering into an agreement to purchase a property, a listed property. Now, that can have a very interesting transition period. You know, right now we've seen a lot of buyers and agents have difficulty getting those agreements signed. We're familiar with those agreements. We can help review and sign and help, get those negotiated for you as well. But right now the laws don't really allow for these buyer representation agreements to be overarching or too broad. There's 90-day periods that can be attached to them with 90-day extensions. And then under that 90-day period, the buyer is potentially exclusively with that agent, but there are more safeguards in place to prevent the ability for a buyer to be trapped with an agent for too long. Now, that buyer representation agreement is supposed to lay out the terms for the agent, the commission, the scope, the timeline, things like that. So what we're seeing is just making sure that the agreements stay within the timelines that are allowed, and then with the commission negotiated, that can be a flat fee, that could be the more traditional commission percentage, but there is some flexibility there. So there's some more negotiation ability between the buyer and agent before they go out together, hopefully to negotiate for the purchase. So you have a question, with all this rental problems going on, so we have a question about tenants being allowed to put locks on their fences and post notices for no one to be able to approach the site, it looks like. Now, while a tenant may be able to protect themselves, secure a property in terms of preventing the landlord from accessing the property, that can be a breach of the lease. If the landlord provides proper notice of the need to enter the property and, inspect, which is relatively simple for most part. So, if the tenant is being potentially aggressive toward the landlord for trying to access the site after being properly noticed, that can be something that can lead to an eviction or at least a breach of the lease itself. So if there are questions about that, let's talk more offline. Let's set up a call and get some more details there to see exactly what the situation is. We have a question about the condominium applicability. So for the applicability there, again, the deadline was supposed to be the first, and then once every 9 years, an HOA would have to go out for a reinspection. Now that was effective this year, and this was not part of the extension period. The extension was related to not non-condominium projects. So condominiums would have the deadline apply for the first of this year. A violation for charges to posting. Now, when we're talking about the violations for charging and posting, we're talking about the landlord charging the tenant for posting a notice. So previously there were landlords that may have charged a fee for posting a notice. Now that is no longer allowed, and that can be something that the tenant can turn around and make it actionable against the landlord for that violation. Let's set up a time. I received a question about notices that need to be given regarding selling the property and how to navigate that with a tenant moving out. I like to set up something offline just to, again, get a little bit more detail. Generally speaking, you have to follow your lease in terms of the ability to post, lead open houses and things like that. But again, with the ability to provide notice to get into the property, to market or sell the property if that is allowed for in the lease. That can be something that, depending on what the terms are, you follow those for notice. Otherwise, working with the client to get open houses and inspections completed is something that, we help with tenants as well. No, in terms of other laws that have taken effect this year, there was an extension we talked about earlier, doubling from 5 business days to 10 business days for eviction response times. Similarly, in the contractor space, handymen previously had a $500 cap on their services before technically needing to have a license to perform the work. Now that cap is extended to $1,000. It was doubled to 1,000, and that is something that is important. If there were handyman services that you rely on now, that can't be stacked services. Those can't be services that tie in payment to a licensed party. Then that does bring in some of the licensing requirements, but just typical handyman services, the cap has been extended from 500 to 1,000. One other large cap increase that has taken effect this year is the small estate exception. Now, for those that have gone through this process, we are big advocates for using LLCs, using trust, other things to avoid probate. Probate can be a very tedious, expensive process with the ability to lose control sometimes of how assets are divided out. Now, with the small estate exception, previously estates that were under $184,000 in value were able to avoid probate and file paperwork to, whether it was a small piece of property or whatever the case was with the assets, be able to get around probate for that small estate. Now, that amount, it leaves a lot to be desired, or left a lot to be desired, because if a house that may not have been, a multi-million dollar house, but still over $180,000 was in play, then you still would have to go through probate. Now, as of this year, the limit has been extended up to $750,000, which is obviously a drastic increase and provides a lot more room and flexibility, the small estate exception to apply. So, if you have questions about that, we have probate attorneys. We don't handle probate attorneys or probate matters in the office, but we probate attorneys, litigation attorneys, trust attorneys that can help navigate this as well to see if a small estate exception may apply now. Does a handyman cap apply to exempt properties? Yes, the handyman cap would apply. Where they're looking at the idea of just making sure that the work doesn't have the ability to stack up to exceed the $1,000. So it can't be part of a major development, major operation, anything like that. But if it's smaller units, handyman services in a house or condo, then there wouldn't be, the cap would still apply. So in terms of the rules on evicting tenants, again, that's a case by case basis. That's a little bit um, dependent, not a little bit. It's dependent on the jurisdiction that the property is in. So again, let's set up a time to talk offline, and we can give you some more direct counseling in terms of what your options are and what the process would need to be to get that property vacated. last before we get to wrap up here, I did want to highlight another law that has taken effect this year that's related to accessory dwelling units. Previously, there was going to be a sunset, essentially, where at the end of 2024, properties that had not been brought into compliance, those being accessory dwelling units, converted garages that had not received permitting by the end of 2024, then they wouldn't be able to receive amnesty from code enforcement for those violations. But that has been extended. That is now extended out until let's see, for the foreseeable future. There is no deadline on the extension, but it is effective now. So that amnesty allows for the waiver of impact fees, again, the avoidance of code enforcement actions and violations, as long as there is progress and work to get the unit into compliance and get the unit permitted. So that's a big win for property owners who might be able to find properties that are a value or have additional add value potential because there is a space that's unpermitted or a space that could be finalized as a permanent unit that just hasn't been. Okay. So let's talk. We are excited to be in 2025. Our goal is to work with as many clients as possible, more than ever, in a way to provide great services. So if you have questions, please feel free to reach out. My number is down below, 619-996-0512. You can follow us on our website, on LinkedIn, Instagram, and Facebook. And you can send us an email at info@SoCalRealtyLaw.com. We would love to feedback on this webinar, any topics that you'd like to see in the future. Like I mentioned, we're looking at discussing LLC formation, accessory dwelling units, lot splits, other things. So if there are topics that are pertinent or that you have had questions about in the past that you'd like us to cover, please send that our way. We'd love to take that into account and get in our suggestion box. So if there are no more other questions, I'll keep the Zoom open just to see if any other questions trickle in. But thank you again for your time. My name's Adam Stone. I really appreciate the ability to present to the group this afternoon.